Mom, I need you to step out of the vehicle. Officer, I'm parked legally. I have a meeting inside this building. You have an unpaid parking ticket from 2 months ago. Step out of the car now. I'll pay the ticket. This doesn't require me to exit my vehicle. Mom, this is your last warning. Exit the vehicle or I will remove you. I'm Judge Patricia Morgan. I sit on the U.S. Court of Appeals. I'm parked in a federal courthouse lot. I have a hearing in 20 minutes. I don't care if you're the Queen of England. You're under arrest for failure to pay. Officer Dennis Crawford had been with the Baltimore Police Department for 11 years when he walked into a situation that would destroy his career and cost the city $5.3 million. He was 37 years old, experienced enough to exercise discretion, but apparently convinced that arresting someone over a $75 parking ticket was reasonable law enforcement. One Tuesday morning in the parking lot of the U.S. District Court for the District of Maryland, he ran a license plate, discovered an unpaid parking citation, and decided to arrest the driver on the spot. The driver was Judge Patricia Morgan, the U.S. Circuit Court judge on the Fourth Circuit Court of Appeals, arriving for oral arguments in a case involving qualified immunity for police officers. What Crawford did next, physically removing her from her vehicle, handcuffing her in front of courthouse staff, and refusing to verify her identity despite her judicial credentials, would become exhibit in a federal lawsuit about how unchecked authority and racial bias create constitutional violations. Patricia Morgan's career wasn't ruined. Dennis Crawford's was, and Baltimore would pay $5.3 million to prove that even federal judges aren't safe from officers who can't separate discretion from ego. A black woman in her mid-50s, Judge Patricia Morgan, was parking her vehicle in the federal courthouse lot at 8:52 a.m., wearing her judicial robe over a navy suit, carrying a briefcase with case files for 3 oral arguments scheduled that morning. Her federal judicial credentials hung on a lanyard around her neck. No crime, no warrant, no danger, just a federal judge arriving for work at the courthouse where she'd presided over cases for 8 years. But Officer Crawford saw her through the lens of an unpaid parking ticket and decided arrest was the appropriate response. Before we continue, where are you watching from? If this is your first time here, please hit that subscribe button. Stories like these need to be shared, and your support helps us bring more truth to light. The U.S. District Court for the District of Maryland sits at 101 West Lombard Street in downtown Baltimore, a modern 7-story building completed in 1977 with limestone and glass facades. The courthouse handles both district court trials and Fourth Circuit Court of Appeals hearings when the circuit court sits in Baltimore rather than Richmond. The building houses courtrooms, judges' chambers, the clerk's office, U.S. Marshals Service offices, and secure facilities for federal detention. The parking lot is on the west side of the building, a secured area with controlled access for federal judges, magistrates, court staff, and authorized personnel. Security is managed jointly by U.S. Marshals and Federal Protective Service officers. Local police have no jurisdiction inside federal property, but can patrol the perimeter and public streets adjacent to the courthouse. On any given Tuesday, dozens of federal employees park in that lot. Attorneys arrive for hearings, judges prepare for their dockets. The system works when everyone understands jurisdictional boundaries. It was 8:52 a.m. on a Tuesday in September. The temperature was 71 degrees with clear skies. The morning commute was winding down. Court staff were arriving for 9:30 a.m. hearings. Attorneys were gathering in the lobby with their files. The courthouse was beginning its daily rhythm of federal justice. The kind of Tuesday morning where procedure and protocol governed everything, until an officer decided parking tickets justified handcuffs. Judge Patricia Morgan had been on the U.S. Court of Appeals for the Fourth Circuit for 8 years. 8 years of hearing appeals from federal district courts across Maryland, Virginia, West Virginia, North Carolina, and South Carolina. She'd written 247 judicial opinions, 189 of them majority opinions in significant cases. Her legal reasoning was cited by other circuits. Her dissents were studied in law schools. Her questions during oral argument were legendary for their precision and ability to expose weak legal arguments. The legal community knew her reputation. She was brilliant, fair, and uncompromising on constitutional principles. She'd authored the majority opinion in 3 cases that reached the Supreme Court, and the Supreme Court affirmed her reasoning in all 3. She'd written opinions on Fourth Amendment search and seizure, qualified immunity for police officers, excessive force claims, and civil rights enforcement. Defense attorneys and prosecutors both respected her fairness. District judges valued her clarity in establishing legal standards. Even lawyers who lost before her acknowledged the quality of her legal analysis. Morgan had graduated from Howard University in 1990 with a degree in political science, graduating magna cum laude. She'd been editor of the student newspaper, president of the debate team, and recipient of the Outstanding Graduate Award. She then attended Harvard Law School, one of 12 black women in her entering class. She'd excelled despite the isolation and occasional hostility. Law Review in her second year, articles editor in her third year, graduation cum laude in 1993. Her Law Review note on Equal Protection Clause jurisprudence was cited in a Second Circuit decision while she was still studying for the bar exam. After law school, Morgan clerked for Judge A. Leon Higginbotham Jr. of the Third Circuit Court of Appeals, one of the great civil rights jurists in American history. That clerkship shaped her entire judicial philosophy. Judge Higginbotham taught her that law was a tool for justice, that judicial opinions had real consequences for real people, and that judges had a moral obligation to protect constitutional rights even when politically unpopular. His mentorship would influence every opinion she'd write decades later. Morgan then spent 15 years at the NAACP Legal Defense Fund, litigating civil rights cases across the country. 15 years of fighting voting rights violations, police misconduct, housing discrimination, and education inequality. She'd argued 12 cases in federal courts of appeals and won 10. She'd argued the cases before the U.S. Supreme Court and won both. Her litigation strategy in a Maryland voting rights case became a model replicated in 6 other states. Her brief in a qualified immunity case was cited in law school cast books as exemplary appellate advocacy. In 2008, she'd been appointed to the U.S. District Court for the District of Maryland by President Bush, receiving bipartisan Senate support. She'd served as a trial judge for 8 years, presiding over 347 trials including complex civil rights cases, criminal prosecutions, and multi-district litigation. Her trial management was efficient. Her evidentiary rulings were consistently upheld on appeal. Her sentencing decisions were thoughtful and well-reasoned. She'd never been reversed for legal error. Her reputation among Maryland lawyers was exceptional. In 2016, President Obama nominated her to the Fourth Circuit Court of Appeals. The American Bar Association rated her unanimously well qualified. The Senate Judiciary Committee held hearings where even opposition senators acknowledged her qualifications. She was confirmed 73-27, with significant bipartisan support. She became the third black woman to serve on the Fourth Circuit. At 48 years old, she'd reached one of the highest positions in American law. As an appellate judge, Morgan had written important opinions on police use of force, Fourth Amendment rights during traffic stops, qualified immunity standards, and civil rights enforcement. Her majority opinion in Henderson v. Baltimore established that officers couldn't claim qualified immunity for arresting someone without probable cause, when existing case law clearly established the unconstitutionality of such arrests. That opinion was cited in the Fourth Circuit and other circuits dozens of times. Her dissent in another case arguing against expanding qualified immunity protections was eventually adopted by the Supreme Court 3 years later. She was considered by legal scholars as a potential Supreme Court nominee, though she'd never sought that attention. Morgan's typical Tuesday routine was consistent. She'd drive from her home in Roland Park to the federal courthouse, arriving between 8:45 and 9 a.m. for oral argument days. She'd park in the federal lot in her designated space marked Judge Morgan, Fourth Circuit. She'd take the elevator to the 4th floor where the appellate courtroom and judges' chambers were located. She'd review case files with her law clerks before arguments began at 9:30 a.m. That Tuesday, September 12th, Morgan had 3 oral arguments scheduled: a qualified immunity case, an excessive force claim, and an employment discrimination appeal. She'd reviewed the briefs over the weekend. She'd discussed the legal issues with her clerks on Monday. She was prepared. She'd left her home at 8:35 a.m., drove downtown, and arrived at the courthouse parking lot at 8:52 a.m. She wore her black judicial robe over a navy suit. Her federal judicial credentials hung visibly on a lanyard with her photo name, title, and the seal of the U.S. courts. She carried a leather briefcase containing the case files and her notes. She looked exactly like what she was, a federal appellate judge arriving for oral arguments. She'd done nothing unusual. She'd violated no law. She'd parked in her designated space in a federal lot. She'd followed the exact routine she'd followed hundreds of times. But Officer Crawford saw an opportunity to exercise authority, and he took it. Officer Dennis Crawford had been with the Baltimore Police Department for 11 years. 11 years of patrol work with a disciplinary record documenting a pattern supervisors had documented but never addressed. Crawford's complaints weren't about racial profiling exactly. They were about something arguably worse, an inability to exercise discretion, a compulsion to escalate minor situations, and a fundamental misunderstanding of when arrest was appropriate. His first documented incident came in year 2, July 2015. Crawford arrested a woman for jaywalking during morning rush hour. The woman was crossing mid-block to reach a bus stop. Crawford witnessed it, pulled over, and arrested her on the spot rather than issuing a citation or warning. Supervisors counseled him about discretion. The arrest was ultimately dismissed. Year 3, November 2016. Crawford arrested a teenager for riding a bicycle on a sidewalk in a residential neighborhood. City ordinance prohibited sidewalk cycling in business districts, but allowed it in residential areas. Crawford either didn't know the ordinance or didn't care. He arrested the teenager anyway. Complaint sustained. Additional training on city ordinances required. Year 4, March 2017. Crawford arrested a man for disorderly conduct after the man questioned why Crawford had pulled him over for a broken taillight. The man's questions were assertive but not threatening. Crawford arrested him for interfering with police duties. The charge was dismissed. Internal Affairs documented a pattern of arrests for contempt of cop rather than actual crimes. Year 5, August 2018. Crawford arrested a woman for failure to provide it during a traffic stop for a broken turn signal. Maryland law doesn't require passengers to provide it during traffic stops. The woman was a passenger. Crawford arrested her anyway. Lawsuit filed. City settled for $45,000. Crawford received a written reprimand. Year 6, January 2019. Crawford arrested a man for trespassing at a shopping mall after the man refused to leave when asked by security. The man was shopping. He hadn't been asked to leave until Crawford arrived and told him to leave, then arrested him 30 seconds later for trespassing. Charges dismissed. Supervisor counseling conducted. The pattern was clear. Crawford used arrest as a first response rather than a last resort. He couldn't tolerate anyone questioning his authority. He escalated situations that required de-escalation. He arrested people for minor infractions that warranted warnings or citations. His supervisors documented these problems in annual reviews. They noted he needed better judgment. They recommended additional training on use of discretion. They suggested he might be better suited for positions with less public contact. But they never removed him from patrol. They never imposed meaningful discipline. They kept assigning him to situations where his lack of judgment created liability. By year 9, Crawford had 19 documented incidents of inappropriate arrests or excessive use of authority. 8 resulted in dismissed charges. 6 resulted in settlements or lawsuits. 5 were sustained complaints. His supervisor's notes were damning. Officer Crawford struggles with de-escalation. Officer Crawford appears to view arrest as appropriate for minor violations that typically warrant warnings. Officer Crawford has difficulty exercising discretion in low-level encounters. But the consequences were always the same. More training, more counseling, more documentation, no real accountability. On the morning of September 12th, Crawford was on patrol in downtown Baltimore. At 8:47 a.m., he was driving past the federal courthouse when he ran a random license plate check on a vehicle turning into the federal parking lot. The system returned a hit for an unpaid parking ticket issued 2 months earlier for street cleaning violation. The fine was $75. The vehicle belonged to Patricia Morgan. Crawford saw an unpaid ticket and decided to make an arrest. He didn't consider that parking tickets are civil infractions, not criminal matters. He didn't consider that arrest for unpaid parking tickets is generally not authorized without a court warrant. He didn't consider calling a supervisor. He didn't exercise any discretion. He saw a violation and decided to enforce it. He followed the vehicle into the federal parking lot, violating the jurisdictional boundary between city police and federal property. He pulled behind the vehicle as it parked in a space marked Judge Morgan, 4th Circuit. He exited his patrol car and approached the driver's door as Morgan was gathering her briefcase. "Mom, I need you to step out of the vehicle." Morgan looked up, surprised. A Baltimore police officer at her door in a federal parking lot. Something was wrong. "Officer, I'm parked legally. I have a meeting inside this building. You have an unpaid parking ticket from 2 months ago. Step out of the car now." Morgan's legal mind processed this immediately. Parking tickets are civil infractions. Police don't arrest for unpaid parking tickets without warrants. This officer was exceeding his authority. "I'll pay the ticket. This doesn't require me to exit my vehicle." "Mom, this is your last warning. Exit the vehicle or I will remove you." This is where minor violations become constitutional crises. Crawford had no legal authority to arrest for an unpaid parking ticket. He had no warrant. He had no probable cause for any crime. He was on federal property without authorization. But he'd decided arrest was appropriate and wasn't reconsidering. Morgan remained calm, her judicial training controlling her response. I'm Judge Patricia Morgan. I sit on the U.S. Court of Appeals for the Fourth Circuit. I'm parked in a federal courthouse lot. I have oral arguments in 20 minutes. I will pay the parking ticket this afternoon. I don't care if you're the Queen of England. You're under arrest for failure to pay. Crawford opened her car door and reached for her arm. This is where it becomes assault. Crawford was now physically removing a federal judge from her vehicle in a federal parking lot without legal authority. The U.S. Marshal, James Wilson, was walking through the parking lot toward the courthouse entrance. Wilson was a 22-year veteran assigned to courthouse security. He'd protected judges for 15 years. He knew Judge Morgan. He saw Crawford pulling her from her vehicle and broke into a run. Morgan pulled her arm back. Officer, you don't have authority to arrest me for a parking ticket. You're on federal property without authorization. I'm a federal judge. Stop this immediately. Crawford grabbed her wrist and pulled harder. You're resisting arrest. That's another charge. Wilson reached them. Officer, release her. That's Judge Morgan. She's a federal appellate judge. You're on federal property. Crawford turned briefly, still gripping Morgan's wrist. This is a police matter. Step back. Wilson's voice rose with urgency and authority. I'm a U.S. Marshal. This is federal property. You have no jurisdiction here. That is a federal judge. Release her immediately, or I will place you under arrest for assaulting a federal official. A court clerk, David Chen, was arriving for work. He'd worked at the courthouse for 12 years. He'd appeared before Judge Morgan dozens of times in his role coordinating case files. He saw Crawford pulling Morgan from her vehicle and pulled out his phone, recording. Another witness, attorney Michelle Torres, was parking nearby. Torres had argued before Judge Morgan 3 times on appeal. She knew the judge well. She saw the confrontation and started recording on her phone as well. Crawford hesitated but didn't release Morgan's wrist. His authority was being challenged. He couldn't back down. I have a legal obligation to enforce the law. She has an outstanding warrant for unpaid parking tickets. Wilson's voice was cold. There's no warrant. I can check that right now. You ran a plate and got a hit for an unpaid ticket. That's a civil infraction, not an arrestable offense. And even if it were, you have no jurisdiction on federal property. Release Judge Morgan now, or you will be arrested. Crawford finally released her wrist, but his face showed no recognition of error. I'm calling my supervisor. Morgan stepped back from her vehicle, shaken but controlled. Her wrist had red marks where Crawford had gripped it. She looked at Wilson. Marshal Wilson, I need this documented. Body camera footage, incident report, witness statements. Wilson nodded. Already on it, Your Honor. Officer Crawford, you need to leave federal property immediately. Crawford pulled out his radio. Dispatch, I need a supervisor to the federal courthouse parking lot. Morgan checked her watch. 8:57 and oral arguments began in 33 minutes. She was now physically shaken, late, and had red marks on her wrist. Wilson escorted her toward the courthouse entrance. Your Honor, are you all right? Do you need medical attention? I'm fine, Marshal, but I want a full report on my desk this afternoon. That officer just assaulted a federal judge over a parking ticket on federal property. Do you think officers who arrest people without legal authority should face criminal charges? Drop your answer below. A supervisor, Lieutenant Karen Foster, arrived at 9:02 am. Foster was a 19-year veteran who'd supervised Crawford before and knew his history. She saw Crawford standing beside his patrol car in the federal parking lot and immediately knew this was serious. U.S. Marshal Wilson was waiting for her. Wilson briefed her quickly. Lieutenant, Officer Crawford just physically removed Judge Patricia Morgan, a federal appellate judge, from her vehicle and attempted to arrest her for an unpaid parking ticket on federal property without a warrant. I intervened and prevented the arrest. Judge Morgan has visible marks on her wrist from where Crawford grabbed her. Multiple witnesses recorded the incident. Foster's face went pale. Judge Morgan, Fourth Circuit. Yes. Foster turned to Crawford. Tell me exactly what happened. Crawford recounted his version. Unpaid parking ticket. Refused to exit vehicle. Removed her from vehicle to effect arrest. Claimed to be a judge. Foster's voice was tight with barely controlled fury. She didn't claim to be a judge. She is a federal appellate judge. You grabbed a federal judge. You attempted to arrest her without legal authority. You did this on federal property, where you have no jurisdiction. And you did this while she was arriving for court. Do you understand what you've done? Crawford's conviction finally wavered. The system said she had an unpaid ticket. An unpaid parking ticket is a civil infraction. You don't arrest people for civil infractions without a court order. You issue a notice. You boot the car. You don't handcuff a federal judge in a courthouse parking lot. Wilson added, and you certainly don't do it on federal property, where city police have no authority. Foster turned to Wilson. Marshal, I apologize on behalf of the Baltimore Police Department. This is inexcusable. Officer Crawford is relieved of duty effective immediately. I'm notifying our Internal Affairs Division and the Chief. Judge Morgan will receive a formal apology from the department. Wilson's expression remained stern. Lieutenant, this isn't just a department matter. This is assaulting a federal official. The FBI will be investigating. The U.S. Attorney will be reviewing for federal charges. And Judge Morgan will likely file a federal lawsuit. Foster nodded. I understand. Officer Crawford, badge and weapon. You're on administrative leave pending investigation. Crawford handed over his badge and service weapon, his hands shaking. For the first time, he seemed to understand he'd just ended his career. Within 3 hours, the cell phone videos were viral. Multiple angles showing Crawford pulling Judge Morgan from her vehicle. Clear audio of her identifying herself as a federal judge. Wilson intervening to prevent arrest. The videos were viewed millions of times. Legal commentators discussed the constitutional violations. Civil rights organizations demanded prosecution. Every federal judge organization in the country issued statements condemning the assault. The headlines wrote themselves. Baltimore cop arrests federal judge over parking ticket. Fourth Circuit judge assaulted by officer in courthouse parking lot. Officer with 19 disciplinary incidents grabs federal appellate judge. The FBI opened a federal investigation within 24 hours. The U.S. Attorney for the District of Maryland reviewed for federal charges. The Baltimore City Council called emergency hearings. The mayor issued a public apology. Judge Patricia Morgan filed a federal civil rights lawsuit 12 weeks later. The suit named Officer Dennis Crawford, Lieutenant Karen Foster for supervisory failure, and the city of Baltimore. The claims were extensive. Assault and battery of a federal official. Unlawful detention without legal authority. Excessive force. Violation of civil rights under 42 U.S.C. 1983. Intentional infliction of emotional distress. Failure to train and supervise officers with documented patterns of excessive authority. The city settled within 10 months. $5.3 million to Judge Patricia Morgan. Officer Dennis Crawford was terminated 16 weeks after the incident. The termination letter was devastating. Officer Crawford physically removed a federal appellate judge from her vehicle and attempted to arrest her for an unpaid parking ticket, a civil infraction for which arrest is not authorized. This occurred on federal property where Officer Crawford had no jurisdiction. Despite Judge Morgan's clear identification of her position and Marshal Wilson's intervention, Officer Crawford insisted on proceeding with an unlawful arrest. This incident represents the culmination of 19 documented cases of inappropriate use of arrest authority and inability to exercise discretion. Despite multiple training interventions and supervisor counseling, Officer Crawford's judgment remained fundamentally flawed. His employment is terminated immediately. Crawford's name was entered into the National Decertification Index. His law enforcement career was over at 37 years old. Should officers who assault federal officials face mandatory federal prosecution? Let me know what you think. The Department of Justice Civil Rights Division launched a pattern and practice investigation of the Baltimore Police Department, focusing specifically on training and supervision failures. The findings confirm systemic problems. 19 documented incidents over 11 years involving Crawford's inappropriate use of arrest authority. 8 dismissed charges. 6 settled lawsuits. 5 sustained complaints. Multiple supervisors noting judgment problems but recommending only training. No meaningful discipline despite clear pattern. A system that documented problems but never removed problematic officers from positions where they could cause harm. Federal reforms were mandated. Immediate removal from patrol for any officer with 5 inappropriate arrest incidents. Mandatory de-escalation training with quarterly assessment and civilian oversight. Automatic federal notification when federal officials or federal property are involved in police incidents. Video recording of all parking enforcement actions involving potential arrest. Independent review board with authority to recommend termination for pattern violators. Prohibition on arrests for civil infractions without judicial warrants. Judge Patricia Morgan testified before a Senate Judiciary Committee hearing on police accountability 8 months after the incident. Her testimony was measured, precise, and powerful. I am a federal appellate judge on the Fourth Circuit Court of Appeals. I have served on the federal bench for 16 years. I have written opinions on qualified immunity use of force and Fourth Amendment protections. I understand the law. I know my rights. And none of that protected me from being physically removed from my vehicle and assaulted over a $75 parking ticket. She paused. Officer Crawford had no legal authority to arrest me. Parking tickets are civil infractions. He had no warrant. He had no probable cause for any crime. He was on federal property, where he had no jurisdiction. I identified myself as a federal judge. The U.S. Marshal confirmed my identity and ordered him to stop. And he continued anyway because he couldn't tolerate someone questioning his authority. Another pause. 19 incidents over 11 years. 8 resulting in dismissed charges because the arrests were legally unjustified. 6 resulting in lawsuits because his use of force or authority was excessive. 5 sustained complaints documenting his inability to exercise discretion. That's not bad luck. That's not isolated mistakes. That's a pattern the Baltimore Police Department documented in supervisor evaluations, in internal affairs reports, in training assessments, and then ignored for 11 years. Her voice remained calm but carried the weight of judicial authority. The city is paying $5.3 million. That's accountability. Officer Crawford was fired. That's consequences. But money and termination don't undo the trauma of being assaulted while arriving for work. They don't erase the marks on my wrist from where he grabbed me. They don't restore the sense of security that even federal judges should be able to part without being physically attacked by police. She looked directly at the committee. If this can happen to me, a federal appellate judge arriving at a federal courthouse with credentials visible and a U.S. Marshal witnessing the assault, what happens to ordinary citizens who don't have my authority? What happens when officers view arrest as the first response instead of the last resort? What happens when departments document patterns of abuse and do nothing? The hearing room was silent. Should documented patterns of inappropriate arrests trigger automatic removal from patrol? Drop your answer. This wasn't about one officer's error. This was about a system that allowed Dennis Crawford to accumulate 19 incidents of inappropriate use of authority over 11 years without removing him from positions requiring judgment and discretion. It was about supervisors who wrote evaluations noting his problems, who documented his inability to de-escalate, who flagged his pattern of arrests for contempt of cop rather than actual crimes, and then did nothing but assign more training. 19 incidents. 8 dismissed charges proving the arrests were unjustified. 6 lawsuits proving his actions violated rights. 5 sustained complaints proving supervisors knew the pattern. Multiple counseling sessions. Multiple training requirements. Multiple documented warnings. And 0 meaningful consequences until he assaulted a federal judge. The pattern was documented. The risk was clear. The department's response was inadequate. They chose protecting Crawford over protecting the public. They chose documentation over discipline. They chose training over termination. Until Crawford's lack of judgment targeted someone with the legal authority and federal position to demand accountability. Dennis Crawford's career is over. That's justice. The city paid $5.3 million. That's accountability. The DOJ imposed reforms. That's oversight. But settlements and policies don't undo the constitutional violations. They don't restore dignity. They don't erase the message that officers can assault people over parking tickets if they believe they have authority. The real question is what changes now. Do police departments finally remove officers after 5 inappropriate arrests instead of 19? Do supervisors finally act on patterns they document instead of filing them for future liability? Do we finally acknowledge that arrest should be a last resort, not a first response to minor violations or challenged authority? Because if we don't fix the systems that kept Crawford on patrol despite 19 documented incidents, if we don't address the culture that confuses authority with judgment, then we're just waiting for the next officer, the next minor violation, the next person assaulted for questioning authority, the next federal lawsuit proving the pattern. Comment if you believe this should be federal law. Officers with 3 or more dismissed charges due to lack of legal authority are automatically removed from patrol and required to pass independent judgment assessments before reinstatement. And if you think these stories need to be told, if you believe accountability starts with awareness and change starts with pressure, then hit that subscribe button. We're not stopping. We're going to keep exposing these patterns. We're going to keep demanding better. We're going to keep fighting for the federal judges, the citizens, the ordinary people who deserve to exist without being arrested for civil infractions by officers who can't exercise discretion. This isn't just about one officer or one judge. It's about all of us and the system we're willing to accept.